Hello everyone, my name is Farhan and today we are exploring a powerful tool in international commercial litigation, the anti-suit injunction, or you can call it as SNI. Simply put, an SNI is a domestic court order commanding a party not to start or continue legal proceedings abroad. Crucially, an SNI acts in personam, meaning it targets the litigant directly, not the foreign court. Banning the foreign court would violate international comedy, so instead, it binds the party conscience. If a litigant disobeys and proceeds abroad anyway, they will face severe domestic penalties such as contempt of court, heavy fine, or asset seizure. So what is the purpose of anti-suit injunction? Why do the court issue them? The primary goal here is to stop forum shopping, where a party seeks a foreign jurisdiction for an unfair advantage. As Barrister Charles Dougherty, King's Counsel, notes, it acts as a shield against foreign procedural disadvantage or tactical delays. Courts generally grant SNI for two reasons. The first one is to enforce a jurisdiction or arbitration agreement. If parties agree to arbitrate in Singapore and then the other one goes rogue and sues in New York, the domestic court issues an SNI to enforce that contract. Second one, to prevent oppressive conduct. Even without an agreement, courts will intervene if foreign litigation is a bad faith attempt to harass, duplicate costs, or undermine ongoing domestic cases, thereby protecting the home court's integrity. So where did this concept of SNI come from? Historically, the SNI began in England as a common injunction by the Court of Chancery to stop an unfair action violating the equitable principle. It expanded to foreign proceeding in the 17th century in the case of Love and Baker. Thought it was initially viewed cautiously as a dangerous case. By 1821, Bushby and Monday broadened the standard to serve the ends of justice, and after a period of strict caution in the 1900s, today's court take an assertive approach. As established in the Angelic Grace, modern court will readily grant an injunction if foreign litigation breaches an arbitration clause. With this foundation set, Rajan will now discuss how this evolved within the European Union.
Now that Farhan has explained the concept of anti-suit injunctions, I'll discuss the development of injunctions in the European Union through case law as well as the Brussels regime. Traditionally, these injunctions were associated with English courts granting such injunctions, and although English courts resorted to discontinuing looking at the competency of a foreign court, the practical effect is a stay of proceedings in another jurisdiction. Thus, it created difficulty within the European Union because the Brussels regime is based on encouraging trust between member states. To address disputes between the parties in member states, the European Union adopted Brussels Convention of 1968, followed by Brussels I regulation in 2001, and later the Brussels Recast regulation in 2012. The cornerstone of this regulation is intended to create a uniform system of jurisdiction and recognition of judgments in civil and commercial matters to encourage trust and proceedings of a member state court, as highlighted by Andrew Dixon. The leading authority was established in the case of Turner and Broad. Upon reference by the House of Lords, the Court of Justice of the European Union decided that the Brussels Convention precludes the grant of an injunction staying legal proceedings in a court of another member state, even where the party is acting in bad faith to frustrate existing proceedings. In this case, the English courts on first appeal granted a broad injunction backed by sections, finding that the Spanish proceedings were brought in bad faith. The decision marks an important point where the Court of Justice pointed out that although proceedings may be brought in bad faith, it must be considered that the member state courts are entrusted with their competence to carry out the effect of carrying out justice, and to that end protecting the aim of Brussels regime. However, the aim of Brussels regulation is not that issues. In Alliance and West Tankers, which concerned a London arbitration, which involved a parallel proceeding brought in Italian courts, the English courts had yet again granted an injunction, where on appeal the House of Lords referred to the Court of Justice of the European Union on the basis that arbitration was excluded in the Brussels regulation. The Court of Justice held that an injunction aimed at restraining a party from commencing a proceeding in another member state was incompatible with the Brussels regulation, even when contrary and in breach of an arbitration agreement. This case marked an interesting conflict, as arbitration was explicitly excluded in the Brussels regime. As Richard Fentiman pointed out, the decision sits uncomfortably between the exclusion provided by the regulation. The Brussels Regulation 2012, the recast, attempted to address some of the criticisms. Recital 12 confirmed that the regulation did not apply to arbitration. However, it also provided Article 31, subsection 2, which provided that a member court that seizes jurisdiction to stay proceedings, thereby arguably permitting an anti-suit injunction. As other scholars have noted, Recital 12 aimed at addressing the uncertainty introduced by West tankers. Nonetheless, later in Gazprom, the Court of Justice distinguished between injunctions issued by courts and tribunals. It held that Regulation 1 did not govern the recognition and enforcement of an arbitral award granting injunctions between two states. Therefore, such injunctions are outside the scope of Brussels regime. Thus, it now seems that Gazprom has reopened the debate. ASI is allowed in arbitration setting, but only within the narrow scope of respecting the agreements between the parties. It, however, relies on the contention whether the anti-suit injunctions are recognized by national courts issued by arbitration tribunals. This leads to the current development, especially after Brexit, and in relation to third state measures, which Jason will now touch upon. Thank you.
As discussed by Ismail, the CJEU traditionally adopted a strict prohibition on anti-suit injunctions in cases such as Turner and West Tankers, viewing them as incompatible with the principle of mutual trust between member state courts. However, recent developments suggest a significant evolution in the EU's approach when dealing with anti-suit measures originating from third states. The UK's exit from the European Union fundamentally altered the landscape of cross-border litigation. While the UK remained a member state, English courts were prohibited from issuing anti-suit injunctions because such measures were considered incompatible with the principle of mutual trust underpinning the Brussels regime. Following Brexit, the UK became a third state and was no longer bound by these restrictions. English courts, therefore, regained the ability to issue anti-suit injunctions and other remedies designed to enforce jurisdiction and arbitrational agreements. This development created new tensions between the UK and EU judicial systems, particularly where English courts sought to discourage proceedings commenced before the courts of EU member states. The Court of Justice ruling in Charles Taylor represented the EU's most significant response to this post-Brexit reality. In that case, an English court attempted to enforce an English jurisdiction agreement by ordering Greek ship owners to pay substantial damages and legal costs for commencing proceedings before the Greek courts. Although the order was framed as a claim for damages rather than a traditional anti-suit injunction, the CJEU focused on its practical effect rather than its formal label. The court concluded that such financial penalties could operate as quasi-anti-suit injunctions because they deter parties from exercising their right of access to justice before competent EU courts. Because economic pressure indirectly undermines the authority of EU courts, the CJEU held that member state courts may rely on the public policy exception to refuse recognition and enforcement of such judgments. Consequently, while post-Brexit courts remain free to issue anti-suit injunctions or award damages for breach of jurisdiction agreements, the enforcement of such judgments within the EU may be denied where they threaten the autonomy of the judicial system. Moving on, developments can also be seen in the field of IP. In China enforcement of IP rights, the European Union secured a legal victory before the WTO concerning China's use of anti-suit injunctions in disputes revolving around SEPs.
Previously, the Supreme Court of China permitted domestic courts to issue extraterritorial anti-suit injunctions against European patent holders, where these orders impose daily penalties of up to £130,000 to prevent patent owners from initiating infringement proceedings outside China. This practice effectively deprived European innovators of their ability to enforce IP rights and pressured them into accepting licensing rates determined by Chinese courts. Following an appeal under the multi-party arbitration arrangement, WTO arbitrators ruled that China's unwritten anti-suit injunction policy breached Articles 28.1 and 28.2 of the TRIPS agreement. China subsequently complied by issuing a Supreme People's Court notice removing the legal effect of these global anti-suit injunctions. Although the EU Commission has welcomed this development, it continued to monitor Chinese judicial practices and is pursuing a separate WTO dispute, the S632, concerning the unilateral setting of global patent royalty rates by Chinese courts. Last but not least, it involved the EU's 20th sanction package. The EU's 20th sanction package, which is enacted through Council Regulation 2026-506 and introduced Article 11CA into Regulation 833-2014, established a targeted anti-suit injunction mechanism to counter Russia's Lugovoy law contained in Articles 248.1 and 248.2 in the Russian Arbitral Procedure Code. Russian courts have frequently relied on these provisions to disregard valid arbitration agreements and exclusive jurisdiction clauses by asserting exclusive jurisdiction over sanctions-related disputes. Under the new EU framework, EU citizens and entities incorporated in member states may apply to national courts for injunctions where Russian proceedings are initiated in breach of such agreements. If the Russian claimant fails to comply with the injunction, member state courts may impose substantial financial penalties against the claimant's assets located within the EU. The mechanism also operates alongside EU's clawback provisions, allowing affected European companies to seek compensation by enforcing claims against equivalent Russian assets located within the Union, where losses have resulted from unauthorized Russian judgments. This represents a significant shift in the EU's approach, where anti-suit injunctions, which were once viewed with caution, are now being used as a tool to protect European businesses from foreign court proceedings that undermine agreed arbitration or jurisdiction clauses. Combined with the EU's clawback provisions, the system both prevents harmful litigation and allows businesses to recover losses when such litigation occurs.
So to wrap things up, the evolution of SNI in the Europe shows a fascinating paradigm shift. As Rajawan explained, the EU historically banned internal SNI under the Brussels regime. The rulings like Turner and Grovey and West Tankers prioritized mutual trust, preventing member states from halting parallel EU proceedings, even those in bad faith. So aside from a narrow 2012 exception for arbitral tribunals in Gazprom, court-issued SNI were frozen. However, as Jason highlighted, geopolitical shift forced a total policy U-turn. The EU now actively deploy SNI against third states. We saw this when the CJEU neutralized post-Brexit English SNI in Charles Taylor, and also when the EU defeated China's aggressive patent SNI as the WTO. So most significantly, Council regulation codified a targeted EU SNI and clawback mechanism to counter Russia Lugovoy law. Ultimately, on and all, a remedy once completely banned to preserve internal trust is now a vital geopolitical shield protecting European businesses from hostile litigation. That's all from us. Thank you so much.